We're going to talk a lot about vindictive prosecution. And I don't mean that in the colloquial sense, like we point to Donald Trump and say, that looks like retribution. He's using the Department of Justice to go after somebody, his political enemy or rival. That looks like vindictiveness. There's a concept of vindictive prosecution, and it's going to be used more and more. We had two prime examples of the Trump administration being charged in a motion to have an indictment dismissed for vindictive prosecution and its related cousin, selective prosecution. One by Kilmer Abrego Garcia, which is up before Judge Crenshaw in Tennessee, and one by Representative LaMonica McIver of New Jersey for the indictment brought against her by Alina Habba. But it's not the only time we're going to talk about it. That's why I wanted to do this sort of as a TED Talk meets a law school class here on Legal AF. You're on Legal AF. Hit the subscribe button. I'm Michael Popok. I wanted to do a teachable moment to teach you about vindictive prosecution under the Federal Rule of Criminal Procedure, Rule 12, under a body of case law coming out of the Supreme Court on down, because we're going to be talking a lot about motions to dismiss indictments or maybe even to stop prosecutions in their track before they even get that far. Maybe to even disband a grand jury, as novel as that sounds, under a theory of vindictive prosecution. So I'm glad you're here. Let's get started on this hot take. The concept of vindictive prosecution and selective prosecution says that a prosecutor is bound and its powers are not limitless. It can only bring good faith prosecutions. It can only start a prosecution and start a grand jury proceeding if it has a good faith basis to believe it will sustain a conviction, at least have probable cause to believe that based on the evidence. Alina Habba didn't have that for LaMonica McIver. The Middle District of Tennessee prosecutor didn't have it for Abrego Garcia. And certainly, as Donald Trump vindictively goes after the icons and idols and leaders of the Democratic Party, Barack Obama, Clinton, Hillary, and Bill, Senator Schiff from California, AG Letitia James from New York, as all of that happens, get ready for vindictive prosecution motions to be granted. And the good thing about the Trump administration is they supply their own evidence to support a motion to dismiss the indictments, because they go on social media, because they go on press conferences, because they go on Newsmax and Fox News, and they give interviews, because everybody in the Department of Justice for Donald Trump is required to be a political hack and do his bidding. That's part of the job description. You must, if you're Pam Bondi, Todd Blanche, or anybody else, it'll be Stan Woodward soon, you must go on all of these social media platforms and all of these right-wing platforms, and you must bash the person who we're investigating, who has been indicted, when that's exactly what you are not allowed to do under the Department of Justice manual and under vindictive prosecution. So these motions have footnotes that go on forever, of citations and hyperlinks to appearances by Alina Habba, by Todd Blanche, by Pam Bondi, and others, senior officials, attacking the person who's under investigation. That is not only vindictive in the common sense, in the street sense, that's vindictive prosecution basis for a dismissal of an indictment. And you normally don't have that. You know, when Donald Trump said, it's vindictive prosecution, it's malicious prosecution, it's selective prosecution. Joe Biden is directing the Department of Justice special counsel to go after me. There was zero evidence to establish that, because there was no meetings between the special counsel and Joe Biden. There were no emails. There were no documents, because there was no connection between the two. But with Donald Trump, this is a guy who publicly extorts people. This is a guy who was adjudged to be a sex abuser. This is a guy who is a fraudster and is the president. And he, in his own cases, created new evidence in real time during breaks that were used in the cases against him. So, of course, his underlings, his sock puppets that occupy the Department of Justice, the most corrupt Department of Justice in history, of course, they're generating evidence that'll be used to support motions to dismiss on vindictive prosecution grounds. I've been doing this a long time. I've been involved with, I think, 2 motions for vindictive prosecution. Only one was granted in 35 years. But here, you normally don't have the gift of evidence that these defendants have. You don't get to cite dozens and dozens and dozens of appearances where they say the quiet part out loud for the Department of Justice. And there's a reason we haven't seen, even though it was threatened, the indictments or the grand jury indictments yet, anyway, of Senator Schiff and Attorney General Letitia James and the others, because all the Department of Justice really wanted was the headlines, the one-day headlines. Federal probe opened up against Senator Schiff and Letitia James for mortgage fraud. They're done. They're done as far as they're concerned. They paid their debt back to their boss, Donald Trump. We got the headline, boss. Of course, they violated their oath, they violated their ethics, they violated the Department of Justice manual, and they violated the law around vindictive prosecution. When Ed Martin, who is the special attorney that's been appointed to go after Schiff and Letitia James, goes on Maria Bartiromo and says the quiet part out loud, I'm not just looking at them for mortgage fraud, I'm going to be cross-examining all of their conduct and behavior. I'll find fraud somewhere. I'll find violations of the law somewhere. Yeah, that's a violation of the law about vindictive prosecution. That's not our system of justice, and that's what the courts say, and that's what the law says. Now, generally, you wait until an indictment is rendered by a grand jury, or if they're traveling, if the prosecutor's traveling under some sort of criminal complaint, you move to dismiss it at the right time. And you bring up the vindictive prosecution, just like Abrego Garcia just did. I just read, and I've been putting up on Legal AF Substack. And that's a great place for you to join us and commune with us in this community. Legal AF Substack. Hit the subscribe button there as well. Subscribe button here on Legal AF YouTube, and then help us. But I post this, the MacGyver motion and the Abrego Garcia motion up in Legal AF Substack for you to read. And when you read the one for Abrego Garcia about, he literally had pages and pages and pages where he could have citations to statements by the Department of Justice, if not the President of the United States, about the vindictive campaign waged against him in retribution because he won his case about constitutional rights in Maryland in front of Judge Zinnes. And that led immediately to the Department of Justice indicting him for no good reason, for bad reasons in Tennessee. And it's all there laid out in the moving papers, and it's all there laid out in the sequential citation to all of these Department of Justice personnel going on television. That's a gift. LaMonica MacGyver goes one step further. Not only does she cite Alina Habba and others who said things out loud that support vindictive prosecution against her, but she also said, I thought the reason that I needed to be brought down was some sort of reference or citation to Jan 6 insurrectionists. All the Jan 6 insurrectionists were let go and celebrated as freedom fighters and patriots. I just went down as a representative of New Jersey, a congressional member of Congress, to go do oversight over a new federal detention center in Newark, and I get arrested and indicted? So I think they have winning arguments here. And I think Adam Schiff and Letitia James are considering doing the same thing. But here's something I posit. I understand that generally the case law is, under normal circumstances, that a federal judge can't interfere with the executive branch's investigation and prosecution of a criminal defendant until there's an indictment. We sort of learned that lesson, did we not, during the Eileen Cannon rulings against her by the 11th Circuit when she tried to interfere on behalf of Donald Trump, her patron, to interfere with the search warrant of Mar-a-Lago before the indictment. Pre-indictment interference by a federal judge is usually frowned upon. Except when you have the evidence that we have about the vindictive prosecution behavior and conduct where they say it out loud in social media and in attacks of the defendant, so that person can't get a fair trial. That person is not presumed innocent, is being convicted in the court of public opinion. I think you have the grounds to have a federal judge stand up and say, stop the prosecution right now. I'm not even waiting for the indictment. You must stop the grand jury in its tracks. I think we're going to see some aggressive motion practice being filed pre-indictment. That's the thing I want you to watch for here on Legal AF. I'll continue to follow it all. So many ways to support what we do. Hit the Legal AF YouTube support button by hitting the subscribe button. But we got this amazing thing called Legal AF Substack. We're putting up 8, 9, 10 pieces a day. We've got videos. We've got lives. I'm doing 2 or 3 lives a day. And if you can help support us, people say, how can we help support you, Popok? It's very easy. I think it's $7 or $8 a month for a paid subscription on Legal AF Substack. You'll get all the filings, all the opinions, the commentary, the people here on Legal AF YouTube channel who are writing over there. You'll get short clips. You'll get real-time, at the moment, at the money analysis within moments of it happening, but you got to be on Legal AF Substack. So until my next report, I'm Michael Popok.
I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touches Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.